Okay, in today's presentation, I am presenting on the topic temporary injunctions and interlocutory orders. Here we have to see Order 39 of the Civil Procedure Code. Here, under Order 39, Rules 1 to 5, it provides about the temporary injunctions. And under Order 39, Rule 6 to 10, it provides about the interlocutory orders. Here, now the general concept of the temporary injunctions. Here, these temporary injunctions at the moment of the proceedings during the pendency of the suit. This order is given provisionally for the time being or intervening some subject matter for the proper disposal of the suit. It doesn't determine the substantive rights of the parties. It is just given provisionally. It is given just aid to the court in the final settlement, final determinations of the substantive rights of the parties. Here, this is the general concept of the temporary injunctions. Here, the object of the temporary injunctions. Here, the primary purpose of granting this interim relief, that is the temporary injunctions, is the preservation of property in the dispute till legal rights and conflicting claims of the parties before the court are adjudicated. That is, here injunctions are two kinds. Here, number one is the temporary injunctions, whatever we are discussing now, and the number two is the permanent injunctions. Here, now you have to clarify about this concept. Temporary injunctions provisions is given under the Civil Procedure Codes, under Order 39, Rules 1 to 5, and the permanent injunctions, it is provided under the Specific Relief Act 1963. Here, from Section 30 to 42. Under the Specific Relief Act 1963, from sections 38 to 42, it provides about the permanent injunctions. At first, you have to clarify about this. Here, now these temporary injunctions can be applied by both the parties of the civil suits. It may be defendant or it may be plaintiff on some grounds, whichever is provided under the Civil Procedure Code. Here, now the grounds for granting the temporary injunctions, you see in Rule 1 at first. Here, grounds for granting the temporary injunctions by the competent civil court. It is provided under Rule 1 of Order 39 of the Civil Procedure Code 1908. Here, now the temporary injunctions may be granted by a competent civil court in the following grounds. Here, number one grounds you see. Here, for any property in the dispute in a suit is in danger of being wasted, damaged, or alienated by any party to the should or wrongfully shown in execution of a decree. Yeah. At first, number one grounds, if the property of the should, if it is being in the threat of wasted or damaged or deprived of such properties by the opposite parties. In these cases, yeah, the aggrieved party, he has right to application for the injunction order. Here, number two grounds here where a defendant threatens or intends to remove or dispose of his property with a view to defrauding his creditors. Yeah. Number two grounds. Here, if the party with the ambition to defraud the creditors. Now, if this party, if it is appears that he is removing such property from such jurisdiction of the court. In these cases, injunctions order can be granted by the competent civil court. And grounds number three, where a defendant threatens to dispossess the plaintiff or otherwise cause injury to the plaintiff in the relation to any property in dispute in the suit. Yeah, if the plaintiff he threatens to dispose such property in relation to the subject matter of the suit. In these cases, competent civil court they have right to grant the injunction orders in favor of the plaintiff. Yeah, and the number four grounds where a defendant is about to commit a breach of contract or other injury of any kind. Yeah. Number four grounds where the defendant is about to commit a breach of contract. If the defendant, if he doesn't want to perform the obligation of the contract, in these grounds, the injunction order can be granted by the competent civil court. And number five grounds here, where a court is of the opinion that the interest of the justice shall require. Yeah. Now the number five grounds is based on the discretionary power of the court. If the court affairs state there is reasonable grounds for the interest of justice shall requires. Yeah. Order 39, Rule 1 of the Civil Procedure Code. It provides about the grounds under which grounds the temporary injunctions order will be granted by the competent civil court. Now, we have got a clear concept of Rule 1. Now, we have to see the some principles at the moment of the granting of the injunctions order by the competent civil court. Here, competent civil court, they have to comply some procedure. That is, here, they have to see some principles. Number one, based on the prima facie case. Here, the first rule is that the applicants must take out a prima facie case in support of the right claimed by him. The court must be satisfied that there is a bona fide dispute raised by the applicants, that there is a strong case for trial which needs investigation and a decision on merits and on the facts before the court. There is a probability of the applicants being entitled to the relief claim by him. Yeah. Number one, prima facie case. It must be established by the plaintiff, that is the applicant. Here, if the court thinks that there is reasonable grounds, there is a prima facie case for the trial, or there need some investigations and inquiry which threatens the rights of the plaintiff. If the plaintiff can establish such threatens by the other party, opposite party, then this provisional order, intervening order by the competent civil court can be granted by the civil court. These temporary injunctions can be granted by the competent civil court. Here, number two, principles. Irreparable injury. Here, the applicant must further satisfy the court about the second conditions by showing that he will suffer irreparable injury if the injunctions spread is not granted, and that there is no other remedy offered to him by which he can protect himself from the consequences of apprehend injury. Yeah. Number two grounds is the principle is the irreparable injury. Yeah. If the court thinks that if the injunction order applied by the applicant is not granted, then some irreparable damage will be caused to the plaintiff. This must be imminent before the court. It must be clear that if the temporary injunctions will not be granted by the court, then some permanent damage, some special damage, irreparable damage will cause to the plaintiff. Based on this, the competent civil court that can give the temporary injunctions orders. And number third, principles the court has to observe. Here, balance of convenience, that is. Here, the third conditions for granting interim injunction is that the balance of convenience must be in favor of the applicants. Here, whatever the injunction order applied by the parties, here the balance of convenience, it must be in favor of the applicants to protect the applicants' rights about the subject matter of the dispute. That is here. And these principles and guidelines, whatever we have discussed, are merely illustrative and neither exhaustive nor absolute rules. Yeah, this is some illustrative. It is not exhaustive all. It doesn't include all. Yeah, based on some eminent grounds also, the competent civil court, they have right to grant the temporary injunctions. It is based on the discretionary power of the competent civil court. Here, now rule 2. Here, temporary injunctions, rule 2. It provides that injunction to restraint, repetitions, or continuance of breach. Yeah, this injunction order, this provisional order, this intervening order is to restrain repetitions or continuance of the breach by the opposite party. It is here rule 2A. A consequence of disobedience or a breach of injunctions. Here, such person to be detained in civil prisons for a term not exceeding 3 months, unless in the meantime the court directs his release. Yeah, if the opposite party doesn't comply with the injunction order, provisional order given by the competent civil court, then the court has right to arrest, right to detain such parties for the and can be put in the prisons for the period of 30 days, unless the court release on some reasonable grounds. Here, number 3, notice. Here, the court shall, before granting an injunction, give notice to the opposite party, except where it appears that the object of granting the injunctions would defeat the delay. Yeah. Now the rule 2a, it provides about the now the rule 3, it provides about the notice. Yeah. Before granting the injunction order, your notice must be given to the opposite parties. It is. And rule 3a, here court to dispose of applications for injunction within 30 days. Here it provides about the limitation period. Whatever the application for injunction, it must be disposed of within the 30 days by the competent civil court. You have to remember about this. Within the 30 days, here this application for injunction order must be disposed of by the competent civil court. Here, now the rule 4, order for injunctions may be discharged, varied, or set aside. Yeah, whatever the injunction order given by the competent civil court, it can be discharged, or it can be varied, or it can be set aside by the parties. It can be made null and void, invalid, by the opposite parties by making application before this competent civil court, which have been granting this order. Here, number rule 5, injunction to corporations binding on its officials. Now, rule 5 provides about the for the corporations. Yeah, if the injunction order is given to the corporations, now it will be binding on its officials. Here we have discussed the clear concept of the temporary injunctions from rule 1 to 5. Now, next, interlocutory orders. It also comes under the concept of the temporary injunctions. That is, here interlocutory orders. That is, here interlocutory orders. It means that here interlocutory. It means not that which decides the cause, but that which only settles some intervening matter relating to the cause, a decree or judgments given provisionally during the course of a legal action. Yeah, these interlocutory orders, it doesn't decide the cause. It only settles the cause. Some intervening matter. It is at the moment of the pendency of the suit. It just settles some intervening matter. That is about the subject matter of the suit, about the subject matter of the litigations. It doesn't dispose the suit. Here, now you see the provisions of the interlocutory orders. It is given under Order 39 from Rule 6 to 10. You have to remember about this. Order 39, Rule 6 to 10. Here, Rule 6. Here, power to order interim shall. Here, Order 6 provides about the power to order interim shall of the property. Here, any movable property which are subject to speedy and natural decay. Yeah. Regarding the movable property, if the movable property is the subject matter of the suit, in these cases, under the interlocutory orders, it can be shelled by the parties to preserve the rights of the parties, that is, which are subject of the speedy and natural decay, which are that if these properties are become worse in short time, if the quality of these properties declines in very short time, then such kind of movable property can be shelled by the parties with the order of the court. That is Rule 6 provides about this. Based on these interlocutory orders, this movable property, which are the subject of speedy and natural decay, it can be shelled by the parties before the final disposal of the suit. Here, rule number 7, it provides about the detentions, preservations, inspections, etc. of subject matter of suit. Here, the court can authorize any person to enter offense or into any land or building in the possessions of any other party to such suit at the pendency of the suit. Here, the court can authorize, with the help of the interlocutory orders, to enter into such disputed subject. It may be land or it may be building. In the subject matter of the dispute, here, with the help of the interlocutory orders, the parties can enter, the party can inspect this property. Here, and the court can authorize any samples to be taken or any observation to be made or experiment to be tried which may seem necessary or expedient for the purpose of obtaining full information or evidence. Here, with the help of the interlocutory orders, here the party, they can they have right to make the observations of this disputed subject. They have a right to be taken the samples or observations of this property for the full informations or for obtaining some evidence for the determinations of these disputes. With the help of these interlocutory orders, they have right to inspections. They have right to take in some information or evidence regarding this subject matter. Here, Rule 7 provides about this. Here, now the Rule 8, application for such orders to be after notice. Here, whatever the interlocutory orders, the competent civil court, they will grant. it must be after giving notice to the parties only. Rule 8 provides about this. Here, now the rule 9. Here, when party may be put in immediate possession of land, the subject matter should. Here, rule 9, it provides about it. Here, the court, with the help of the interlocutory orders, they can order for the immediate possessions of this land, which is under the subject of the dispute. Here, where this should land is liable to payment of revenue to governments or a tenure liable to sell, and the party in possessions of such land or tenure neglects to pay revenue or rent, neglects to pay revenue or rents, any other party to the suit claiming an interest in such lands or tenure may, on payment of the revenue or rent due, be put in immediate possessions of the property. Here, with the help of this rule number 9, interlocutory orders, the competent civil court, they have right to order. Here, if the land which is the subject matter of the suit, here, if it is the liable to payments of revenue of the government and liable to payment of the rents, if the party doesn't pay such amount, such revenue or rent, here the other party who is claiming under this land, under this subject matter of the suit, they have right to immediate possessions by paying such revenue to the government or rents to the government with the help of these interlocutory orders. Here, the court may award in the decree the amount shall paid with the interest thereon against the defaulter. Here, and with the help of this rule 9, the court can award the decree whatever the amount paid by such parties who had taken immediate possessions, the amount shall paid with interest by the defaulter. This decree can be given by the competent civil court. Here, the rule 10. Here, deposit of money, etc. in court. Here, this rule 10 interlocutory orders, it provides that where the subject matter of a suit is money or some other thing capable of delivery, and a party to a suit admits that he holds such money or thing as a trustee for another party, or that it belongs or is due to that party, the court may order it to be deposited in court or delivered to that party with or without surety. Yeah, this rule 10 of interlocutory orders, it provides about it. Yeah, in case of the money or other thing which is capable of being deposited in the court, in these cases, the court will granted interlocutory orders for deposition of this amount or deposition of this thing, whatever the property there is. If the party they have said that they have been holding this property as a trustee for that party, Here, this party, they have right to deposit in the court, and the court will give the party who is entitled to such money or property. That is here. Up to this, we have clearly discussed about the provisions of the temporary injunction, general concept of the temporary injunctions, and the provisions rules under the order 39, both the temporary injunctions and the interlocutory orders it is given. Here you have to remember from rule 1 to 5 of order 39, it provides about the temporary injunctions, and from rule 6 to 10 of order 39, it provides about the interlocutory orders. Here we got a clear concept about the grounds of granting the temporary injunctions, grounds for granting the interlocutory orders. I think we have got a clear concept. Okay, that's all.